The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Voulez-vous asseoir?
Good afternoon, everybody. The court is in session. Would the court officer please call the case?
Good afternoon, Mr. President, Your Honors. The situation in the Republic of Mali in the case of the prosecutor versus Ahmad al-Faqi al-Mahdi, case reference ICC 0112-0115.
Thank you. I'm Judge Howard Morrison, and I'm the presiding judge in this appeal in the case of prosecutor against Mr. Ahmad al-Faqi al-Mahdi. Today, on behalf of the Appeals Chamber, I will be delivering the judgment on the legal representative of victims' appeal against the Reparations Order of Trial Chamber 8, filed in accordance with Article 82(4) of the statute. The Trial Chamber's decision was rendered on the 17th of August 2017. In today's summary, I will refer to it as the impugned decision, and I will refer to Trial Chamber 8 as the Trial Chamber. The other judges of the Appeals Chamber on this appeal, and who join me today, are Judge Sylvia Fernandez de Gamendi, Judge Sanjeev Monageng, Judge Christine van der Weingart, and Judge Piotr Hofmansky. I am also joined by legal staff of the Appeals Division, Mr. Volker Nerlich, Ms. Barbara Roche, Mr. Anthony Abato, Ms. Chitrandas Singh, and Ms. Annabel Gary. Now may I ask the parties and participants to introduce themselves for the record, starting with the legal representative of victims.
Merci, Monsieur le Président, Messieurs et Madame les juges. Je suis Maître Kasongo Mayomo, avocat, représentant légal des victimes. Mon équipe est composée aujourd'hui de Maître Aline Delay qui m'assiste, avec Mademoiselle Sarah Benaïssa qui compose cette équipe. Merci beaucoup.
Merci. And now for the defense.
شكرا سيد الرئيس. السيدات والسادة القضاة المحترمين، أنا الأستاذ محمد عويني المحامي للسيد المهدي، وتعاونني في هذه الجلسة السيدة سيلفيان إما جولجينو والسيدة جوديت أكيبي. شكرا سيد الرئيس.
And now the trust fund for victims, please.
Mr. President, Your Honours, good afternoon. I'm Peter de Baan. I'm the Executive Director for the Trust Fund for Victims, and I'm joined by Ms. Erin Rosenberg, Associate Legal Officer with the Secretariat of the Trust Fund.
Thank you very much. Now I shall summarise the public version of the Appeals Chamber's judgment, which was taken unanimously. This summary is not part of the written judgment, and please note that only the written judgment is authoritative. The written judgment will be filed in a confidential version and a public version, and it will be notified to the parties shortly after this hearing. During the course of today's hearing, I will refer to Mr. Ahmad al-Faqi al-Mahdi as Mr. al-Mahdi, and the legal representative of victims as the LRV. Before I summarise the Appeal Chamber's judgment, I recall that Mr. al-Mahdi was convicted as a co-perpetrator under Articles 8(2)(e)(4) and 25(3)(a) of the statute for intentionally attacking 10 protected objects in Timbuktu, Mali, between around the 30th of June 2012 and the 11th of July 2012, and was sentenced to 9 years of imprisonment. I will refer to those 10 protected objects as the protected buildings. I shall begin with a brief account of the relevant procedural history. The LRV filed its notice of appeal in this case on the 18th of September 2017 and its appeal brief on the 18th of October of 2017. Pursuant to the Appeals Chamber's directions on the conduct of the appeal proceedings, the Trust Fund filed its observations on the LRV's appeal brief on the 29th of November 2017, to which Mr. Mahdi and the LRV responded on the 11th of December 2017. Mr. Mahdi did not file a separate response to the LRV's appeal brief, although general arguments related to the appeal were included in its response to the LRV's appeal brief. And I now turn to the merits of the appeal. The LRV raises two grounds of appeal, and I will treat them in order. Under his first ground of appeal, the LRV submits that the trial chamber erred in limiting individual reparations for economic loss to those whose livelihoods exclusively depended upon the protected buildings. The appeals chamber notes first that a trial chamber in making an award for reparations has discretion, explicitly circumscribed only by the scope and extent of any damage, loss and injury as per Article 75(1) of the statute and Rule 97(1) of the Rules of Procedure and Evidence. In reaching its decision, a trial chamber shall take account of parties' submissions as per Article 75(3) of the statute, and it may appoint appropriate experts to assist it in determining the scope, extent of any damage, loss and injury pursuant to Rule 97(2) of the Rules of Procedure and Evidence. The appeals chamber notes that the trial chamber, in analysing the different kinds of harm alleged in the information before it, stated that it freely considered all submissions, applications, supporting materials, expert reports, and other relevant information. The appeals chamber finds that the LRV has not shown that the trial chamber abused its discretion in reaching the decision it did, given the information it had before it, and finds no error in the trial chamber's determination of the category of victims who should be entitled to individual reparations for economic loss in this case. Turning to the second ground of appeal, the LRV argues that the trial chamber erred in delegating a power of adjudication for reparations to the TFV, a non-judicial entity. He also challenges the trial chamber's findings on the confidentiality of the victim's identifying information. On his first argument related to the alleged delegation of power to the TFV, the appeals chamber notes that the trial chamber considered that the names of the victims meeting its parameters for individual reparations were simply not known, and considered that it would be impracticable for the chamber to attempt to identify and assess all of them itself. The trial chamber therefore considered it best that individual reparations be awarded on the basis of an administrative screening by the TFV. The appeals chamber considers that the trial chamber's decision is in conformity with Rule 98(2) of the Rules of Procedure and Evidence and the underlying rationale of this provision, namely, that there may be situations in which it may be impossible or impractical to make individual awards directly, and that the trial chamber may need to rely upon the TFV to enhance the efficiency and effectiveness of the reparations process. The appeals chamber finds that it is within the discretion of a trial chamber to request on a case-by-case basis the assistance of, for instance, the TFV to undertake the administrative screening of beneficiaries of individual reparations meeting the eligibility criteria set out by the trial chamber. The appeals chamber therefore finds that the trial chamber did not err in this respect. However, the appeals chamber finds that it is for the trial chamber, in the exercise of its judicial functions, to make final determinations on individual victims' applications where administrative decisions of the TFV are contested or proprio mutu. Therefore, the appeals chamber amends the impugned decision to the extent that applicants for individual reparations should be able to contest before the trial chamber the decision taken by the TFV on their eligibility for individual reparations, and it is for the trial chamber to make the final determination in this respect. In relation to the second argument raised by the LRV under his second ground of appeal regarding confidentiality issues, the appeals chamber first notes that the LRV requests that the appeals chamber grant initial measures of confidentiality in order to ensure that identifying information of victims who sought anonymity is not transmitted to the TFV or Mr. Al-Mahdi without their consent. In this respect, the Appeals Chamber observes that the trial chamber stated that no identity of a reparations applicant may be transmitted to the TFV or defence without the victim's consent. Therefore, in the view of the Appeals Chamber, the trial chamber did not lift any protective measures, and the Appeals Chamber dismisses the LRV's argument as not arising from the impugned decision. Second, the Appeals Chamber notes that in its submissions before the Appeals Chamber, the LRV also raises more general concerns as to the disclosure of information relating to the identity of applicants to both the TFV and Mr. Al-Mahdi. The Appeals Chamber recalls that the trial chamber stated that anyone who wishes to be considered for individual reparations must make their identity known to both the TFV and the defence. The Appeals Chamber notes that in the proceedings prior to the issuance of the impugned decision, the identifying information of applicants had been withheld from Mr. Al-Mahdi. The Appeals Chamber recalls that when ruling on requests for redactions, a trial chamber must take into account and balance the rights and interests of the parties as per Article 68 of the statute. That provides that the court shall take appropriate measures to protect the safety of victims and witnesses. These measures shall not be prejudicial to or inconsistent with the rights of the accused in a fair and impartial trial. The Appeals Chamber notes that Mr. Al-Mahdi's interests at this stage of the proceedings are limited. The trial chamber has already set Mr. Al-Mahdi's monetary liability, and, as argued by the LRV, the results of the screening process will have no impact upon this. Given the particular circumstances of this case, the Appeal Chamber finds that in balancing the interests of the parties at issue, the trial chamber failed to justify why it was appropriate to essentially place the victims in the position where they would have to choose between security concerns and their eligibility to be granted individual reparations. The Appeals Chamber finds that the trial chamber erred in ordering that access to applicants' identifying information should be granted to Mr. Al-Mahdi as a condition for the applicants to have their applications for reparations reviewed by the TFV. This finding is reversed and the impugned decision amended to the extent that the TFV is authorised to also consider applications for individual reparations made by applicants who do not wish to have their identifying information disclosed to Mr. Al-Mahdi. The Appeals Chamber also notes that the LRV has also argued against disclosure of identifying information to the TFV. The Appeals Chamber considers that for the TFV to exercise the screening, it needs to be able to verify the identity of the applicants. Therefore, victims who wish to obtain individual reparations must make their identity known to the TFV or consent for such information to be transmitted to the TFV. The overall conclusion is thus: the Reparations Order is amended to the extent that 1. The victims' applicants who wish to be considered for individual reparations but do not wish that their identities be closed to Mr. Al-Mahdi may nevertheless participate in the administrative screening process that the Trust Fund for Victims will carry out. In that case, their identities will be disclosed to the Trust Fund for Victims but will not be disclosed to Mr. Al-Mahdi. Victim applicants who the Trust Fund for Victims finds as a result of the administrative screening are ineligible for individual reparations are entitled to request that the trial chamber review the assessment by the Trust Fund for Victims. The trial chamber may also review the assessment by the Trust Fund for Victims proprio mutu. The remainder of the Reparations Order is confirmed. This concludes my summary of the judgment, and I thank the interpreters, the court officer, the parties and the participants, and this session is now closed. We are delivering a judgment in the case of the prosecutor against Jermaine Katanga and the appeal that's attached to that, and we will do that in approximately 15 minutes' time.
All rise.